Next up, we will be doing the same rules for this bill as well, under 1605. Representative Pinto, you have a motion.
Mr. Chair, again, I move that this bill simply take the next step in the process to allow the discussion to continue. The next step, which is to have the bill be re-referred to the Civil Law Committee, where the discussions and the point that was just made with the last bill can continue to go on. And so I would urge, so that's the motion that I'm making. Thank you, Mr. Chair.
Go ahead with your testimony.
Thank you, Mr. Chair. Members, House File 1605 is a second bill that would help to keep firearms away from dangerous people. We heard in the last testimony about that being the concern, is the people involved. This bill would do that while protecting the rights of the many, many, many responsible gun owners. Gun Violence Protective Orders, or GVPOs, are a legal tool that family members and law enforcement can use when the evidence is clear that someone is posing a significant danger. In my work as a prosecutor, I see those situations, those red flags warning of danger, but nothing can be done. Well, in 5 states, including Indiana, right now, something can be done. And I'll point out, this tool, just like the last one, is used in other states. It's fully constitutional. It's being used all the time in other states across the country. And that's something that can be done is a GVPO. Members, a GVPO, again, is a request made to the court by family members or by law enforcement. And the court, in response, considers concrete evidence and past actions and assesses, is this person a significant danger? Not just a danger, but a significant danger. And these are legally really important words to other people or themselves. And are less restrictive alternatives not adequate, not appropriate? So it's not just significant danger. The court has to find the second step as well. And if so, there is a temporary prohibition on the possession of firearms. Firearms have to be transferred to someone else, not necessarily law enforcement, to a dealer, to an FFL, to another third party. And there is an exception, even in that, for certain recreational activities. A person can have firearms back for hunting, et cetera, and you can look at the bill on that. Members, there are many due process protections in the course of this bill. Making a false accusation and bringing this to court is a crime. It's perjury. It's a felony. And also, by the way, you can bring a lawsuit against the person, too, civilly and criminally liable. There is a full hearing before the order is issued. The person is given notice, of course. They present their side. I should note the person who's bringing the motion in the first place has the burden to show it. There can be a situation in which there's emergency order issued. But if so, that's only if the danger is really extreme, has to be immediate, has to be imminent and present. And even then, a full hearing has to be held within days. The order is based on past conduct. The order, members, again, is temporary. And the person can certainly seek an order, getting it to be lifted. A reminder that all the constitutional rights still apply. I've seen a lot of discussion about search and seizure and various issues relating to this. They all still apply, and really, members, we're very familiar with protective orders in domestic violence situations and others, orders for protection, harassment restraining orders. This is the same process. This is a restraining order. It's the same process as those other orders when these certain circumstances apply. Members, I would urge you to listen to the testimony and to consider this tool that is being used right now in a number of other states. And I'll bring up my first testifier, Chief Schnell.
Chief Schnell, please state your name for the record and you may proceed.
Good day. My name is Paul Schnell. I'm the Chief of Police for the City of Inver Grove Heights, speaking today on behalf of the Minnesota Chiefs of Police Association. I want to thank you for the opportunity to speak in support of House File 1605. We stand firmly in support of this legislative proposal. We understand that there is no one single fix to the problem of violence perpetrated by those whom we all agree should not be in possession of a firearm. It is undoubtedly true that people who are a danger to self and or others because of mental illness should be prohibited from owning firearms. It is less clear, however, how to tailor new policies to better protect Minnesota's public while at the same time avoiding the stigmatization of those with mental illness. Any strategy to address a lethal intersection between guns and mental illness should focus on three key elements. First, there should be we need to recognize that overwhelmingly, the majority of people with mental disorders will never, ever engage in violence against others. And two, most violent behavior is due to factors other than mental illness. And three, psychiatric disorders such as depression are strongly implicated in suicide, which accounts for more than half of all gun fatalities annually. On a regular basis in Minnesota, police chiefs or sheriffs are approving permits to purchase or returning firearms to persons our officers have dealt with, and in some cases placed on an involuntary transport hold for psychiatric evaluation. Many chiefs have been in the uncomfortable position of having family members request that guns previously taken for safekeeping be held because their family member or loved one remains unstable. Despite these requests by concerned family members and the articulable belief that the person reflects a true and present danger to self or other, the current law demands that guns be returned to the person for lack of a qualifying reason to withhold the return of those guns. We believe that a gun violence protection order is a de-escalation tactic that will ultimately address these issues. We believe that the GVPO will provide us with a tool that can help us keep our communities safe in what we know to be rare situations. Even while these situations may be rare, I would remind everyone that today there is a community in Florida that wishes that any and all tools available to them would or could have been explored. The Minnesota Chiefs of Police Association urges your support of House File 1605. Thank you.
And Mr. Chair, with your permission, I'll bring up the next testifier, Sheriff Jack Searier.
Sheriff, please state your name for the record, please.
Mr. Chair, members, my name is Jack Searier, S-E-R-I-E-R, and I am coming to you today, I'm speaking to you as the Ramsey County Sheriff. I have been in Minnesota law enforcement for 28 years, and I spent 12 years working the street, some of which were out the front door of this building as a member of the St. Paul Police Department. So I've had a firsthand view of the fear and concerns that law enforcement officers and family members have for those who are in crisis and have access to firearms. As sheriff, it is my role as an executive of a law enforcement agency to abide by the laws of the state, no matter what they are. I cannot pick or choose which laws to enforce or to overextend my reach as a public official. As such, I would like to advocate for the Gun Violence Protection Order bill being offered by Representative Pinto. This is a common sense bill that will allow those closest to a crisis situation to request a due process hearing about the status of a person's possession of firearms when family or law enforcement witness behaviors that are putting the person subject to the order, their own life in jeopardy or the lives of loved ones around them in danger. We in law enforcement find ourselves close to many situations where the law falls short of protecting people from themselves or creating better safety nets for others around them. The behaviors we see from some people often leave us concerned and lacking the tools to intervene as we see a situation build to what, at times, becomes a tragic ending. I'm asking for your consideration of House File 1605 as a common sense measure to ensure the safety of people in our communities here in Minnesota. Thank you.
Sheriff Searier. Thank you.
And Mr. Chair, the next testifier is Merritt Brock.
Please state your name for the record.
Yes, my name is Merritt Brock, B-R-O-C-K. I live in St. Paul. I'm a volunteer with Moms Demand Action, a mom, and I'm a gun violence survivor. I'm here today in honor of my brother who died by suicide with a gun and to urge you to support gun violence protective orders. My brother was the baby of our family. His name was Philip, but everyone called him Pip even when he grew into a big bear of a man. He was a Minnesota guy through and through. He loved hunting, fishing, camping, skiing, Whatever got him outdoors, he loved it. Unfortunately, on August 21st, 2001, he took the hunting gun that our grandfather had given him and shot and killed himself. He was 26 when he died. Today's his birthday. He'd be 43 today. My brother's death made me an activist dedicated to preventing suicide. And over the years, I've met so many people worried about a loved one in crisis. And one woman in particular comes to mind because she was terrified for her adult son. He'd stopped taking his medication. His behavior was erratic. He refused to give up his guns. And when they went to law enforcement, they were told that there's nothing that they could do unless something happened. She was terrified for her son, his wife, and their kids because she knew if they waited until something happened, it would be too late. Currently in Minnesota, there's no action that a family member can take regarding red flags. Between 2012 and 2016, 3,400 Minnesota residents have died by suicide, and nearly half of those have been with a gun. You heard earlier that the primary amount of gun deaths in Minnesota is gun suicide. Gun violence protective orders would allow family members, who are usually the first to see red flags, to alert law enforcement, who can then take action to seek a protective order to temporarily remove guns from people in a dangerous situation. This is law in a number of other states across the country. It's tested, and a 2017 study of Connecticut's law estimated that more than 72 people are alive today thanks to their law. I know that there's not one law that will end all gun deaths, and this law wouldn't have prevented my brother's death, but I know that gun violence protective orders will save lives in Minnesota, and I urge you to support this bill. Thank you.
And Mr. Chair, I'll call up the final testifier.
Please state your name for the record, please.
Hi, my name is Eva Goldfarb. I'm a junior at St. Louis Park High School. Thank you guys for this opportunity to speak to you from my position as a student. A few days after Parkland, I went to bed and I had a dream where my own school was targeted by a shooting. When I went to tell my friends, a lot of them said they had the same dream. I wanted to say, gosh, what a horrible nightmare, but I realized it can't even be classified as a nightmare because even though it has monsters and terror, nightmares aren't real. This is all too real, and we know it too well, and we've known it for too long. We know that if people who are dangerous can't have a gun, then they can't shoot people. Why are we surprised every time a person with a semi-automatic assault weapon fires on a crowd of people and kills so many? This is now a regular occurrence. We, the students, call on you to enact preventative gun control laws like GVPO. I say preventative because my best friend's father committed homicide and suicide, and it could have been prevented with a bill like this. She could still have her mother and her grandmother today if this process was used. It could have been prevented. You are our legislators, and it is your job to keep us safe from gun violence in our schools and in our movie theaters, our universities, our concerts, our churches, synagogues, and mosques, on our streets and in our communities. We are asking you to prevent shooters before they've done their damage. Make it possible to remove the guns that enable dangerous people to kill. If there are red flags about a person, their family or community police or peers know they might be dangerous, then the law must allow family and police to prevent them from having a gun. I know of an 8-year-old girl that asked her mom for new sneakers because she realized her light-up Skechers ones would give away her location in the case of a school shooting. How much are our lives worth to you? Because we are committed. Gun reform is no longer a question of if, but a question of when, and the answer is right now. Please vote yes on this bill and allow for gun violence protection orders as one way of helping to keep us safe. You may think students will lose interest in this issue, but we won't. Not until we can learn about how to better the world around us instead of learning how to lock the door and hide in the corner as quickly as possible. Not until that little girl can wear Skechers without the fear of getting killed. Not until thoughts are replaced with action and prayers replaced with laws. Another thing I wanted to quickly mention is a big theme that I've heard in people's testimonies as well as conversations I've had with people outside in the halls is the theme of this burden that these bills impose on them, of having to go through longer and more bureaucratic processes that make it harder. But if I'm being honest, we have a burden too. It is a burden for us to go through these lockdowns regularly. It is a burden for us to have to plan walkouts. It is a burden for us to wake up and go about our regular lives with the fear that we may be shot. It is far beyond just a burden for us and these families of victims to grieve the losses of their loved ones. So with all due respect, and I don't want to minimize the validity of this burden, but my safety and the safety of my peers and the safety of everyone is worth the burden. Thank you for your attention.
Just to conclude, Mr. Chair. Thank you. Mr. Chair and members, no one policy change would prevent every one of the deaths that have been described today. Of course not. But these are both reasonable steps that are in use across the country and that are saving lives today while still fully protective of the rights of gun owners. In the domestic violence fatalities and homicides that take up so much of gun deaths, in the cases that I prosecute, the good guy with a gun is not going to be helpful. That's in a situation where someone who has shown in their behavior that they are dangerous, right now we don't have that tool. This would give us that tool. I would urge you members to continue this bill through the process, to have the next hearing in the process to continue, because I think everyone in the room would agree we need something like this. And if your problem is the details, let's keep working on it, move it through the process. Thank you, Mr. Chair and members.
Next, we have Rob Dorr.
Thank you again, Mr. Chairman and members of the committee. Gun violence restraining orders.
Please state your name.
I'm sorry. Okay. Rob Dorr, D-O-A-R, with the Gun Owners Caucus, political director. Gun violence restraining orders are a noble idea. We support finding ways that family members can intercede with people who they think are at risk. And we are willing to be part of that conversation and ready to be part of that conversation. But our concerns can, as you can guess by our buttons, can be summed up with two words: due process. The process of gun violence restraining orders that we particularly object to are the ex parte provisions, which allow, based on an accusation, for somebody's firearms to be seized from them and then justified, have their chance to have their day in court and justify whether or not they should or should not be able to repossess their property. Our Constitution guarantees that no person shall be deprived of life, liberty, or property without due process. This bill is confiscation without due process, period. If this bill were to become law, an individual's constitutional rights would be violated not because of guilt beyond a reasonable doubt, not even clear and convincing evidence, but mere preponderance of the evidence. That of only one side of the story. Preponderance of the evidence of only one person's side of the story. They can have their property and their gun rights, their right to self-defense taken away from them. The potential of abuse for this is egregious. Because this bill violates the Second, Fourth, Fifth, and Sixth Amendments, we vehemently oppose this bill and encourage every member to vote to table it.
Next, Sarah Cade. Please state your name for the record and continue.
Mr. Chair, members of the committee, my name is Sarah Cade. I'm a resident of Maplewood, Minnesota, a healthcare professional and a recreational shooter. I'm a volunteer activist, and I'm speaking today on behalf of the members of the Minnesota Gun Owners Caucus and Political Action Committee. We oppose this legislation. HF 1605, the Guilty Until Proven Innocent bill, completely guts the concept of due process. This bill allows civil rights to be stripped without representation, without even your knowledge, and without the chance to present evidence on your behalf. Since it only requires a preponderance of evidence, an extremely low burden of proof that is normally used in civil trials. The Second Amendment is a constitutionally protected fundamental human right, and this bill treats it like an episode of Judge Judy. Rights matter, even and especially when they're controversial. Many of the people in the gallery today came over from the pro-choice lobby day. They understand better than anyone that controversial rights need the protections of our system the most. And it's not just controversial rights, but controversial people who need that protection. And this is not a purely philosophical debate for me. I grew up in a family with domestic abuse, and I have lived the terror of hiding in a battered women's shelter, afraid of what would happen if we were found. But the rights we're discussing today are bigger than my fears. Due process is the foundation of a just legal system. It's vitally important to protect it from erosion, and that same protection applies equally to everyone. When it comes to suicide, I can tell you this bill would do more harm than good. Most people in Minnesota commit suicide with firearms they already own. So that means they're gun owners like us. We're your friends and your neighbors. If you want to help us, the first thing you need to do is understand us. Most gun owners believe, and research shows, that the best methods for suicide prevention are proactive and they're voluntary. Laws like this drive gun owners away from mental health treatment and make us less likely to reach out for help, whether that be treatment for depression, PTSD, marriage counseling, or any of the everyday problems we all share. If you were to ask how many people here know someone who chose not to seek help for fear their medical records would someday be used against them, I bet you would see a lot of hands in the air. We're all in this together, and we need to address these problems as a community. Laws like this only create more stigma and discourage people from reaching out. This is an unseen problem, but our lives matter too. Ladies and gentlemen of the committee, I know you're under a lot of pressure to do something, but that doesn't mean you have to act recklessly without considering the cost of these proposals. This bill is dangerous and it's counterproductive. As lawmakers, your constituents rely on you to carefully consider the unintended consequences and make a decision that protects the rights of all Minnesotans. Please vote against HF 1605. Thank you.
Representative O'Neill.
I can hold my questions till the end, Mr. Chair, after they have the other testifiers. Thank you.
Okay, thank you. Maybe if everybody could wait their questions till the end. Kara Schultz.
Committee persons, members of the audience, I'm Kara Schultz, and I'm here representing the Libertarian Party of Minnesota. Libertarians ascribe to an ethic of assuming good faith until proven otherwise, and I mention this because we believe every person in this room is here because we all have this shared wish for a peaceful society, and so do we. But we do have significant concerns regarding HF 1605. While we do not believe it is the author's intent, this bill is discriminatory in its nature towards minorities and persons in lower socioeconomic classes. A wealthier person is able to easily hire an attorney, experts, that type of thing, to defend themselves against accusations that they pose a danger, and they can recover their civil rights. Lower income persons would be at a serious disadvantage. As for minorities, well, we did hear from Ben Rust, who works with gun trust and firearms issues as an attorney, and he notes the majority of his clients who need to take legal action to recover their rights regarding firearms are often named Mohammed, and that's not a coincidence. We also have concerns regarding inadequate due process. A person can be stripped of their rights first due to someone's feeling they may pose a danger, and then they have to go to court to recover their rights, and we feel that that is backwards in the process. Now, there is a standard used by court, which also has a concern for us, which is preponderance. And that means a judge just needs to feel about 51% that a person could possibly be a danger. And that standard is far too low for something as serious as stripping away a person's civil rights. We are concerned that this bill is ripe for abuse. Not only could feuding family members use it as a way to retaliate against one another, if you've been in family law, you've seen this, or try to gain possession of valuable family heirloom firearms, it could be used in very tragic ways. Now, if a wife were to leave her husband due to abuse and purchase a firearm for protection, an estranged husband could use this process to disarm her Well, we see there is a provision in the bill that speaks to these false allegations, and we appreciate that. We all know that this is extremely notoriously difficult to prove and prosecute. Now, we can see the aim of this bill looks squarely at mental illness, but we believe the results would be counter to what the bill's authors hope to achieve. Provisions that allow for notice to be served in a local newspaper would broadcast to the public that the named person is mentally ill and dangerous. Provisions which allow a person's private medical records to be given to police would make people far less likely to seek assistance if they need help, and less likely to discuss serious health concerns like depression or anxiety with their family doctor. The entire bill unfairly, according to every scrap of research available, stigmatizes those with mental health challenges as violent and untrustworthy. We question the focus of this bill. If the goal of the bill is to protect the public from people who pose such a danger to themselves or others that a court must take emergency action, the bill would be about removing the person to a safe location for 72 hours for evaluation by trained medical professionals, not leaving them on the streets where they still pose a danger to themselves and others. Now, Minnesota already has a law to involuntarily evaluate someone suspected of posing a danger to themselves or others over a 72 period. And that is the tool which could be utilized, not just for public safety, but to compassionately offer mental health services to those in desperate need. The Libertarian Party of Minnesota opposes this bill due to its discriminatory nature, potential for abuse, inadequate due process before stripping a citizen of a civil right, violations of medical privacy, stigmatization of mental illness, and ineffectual focus. Thank you.
Thank you. Professor Joe Olson.
Mr. Chairman, Representative, members of the committee, I'm Joseph Olson. I'm president of the Gun Owners Civil Rights Alliance of Minnesota. We represent the interests of Minnesota's 2.5 million law-abiding gun owners. We don't represent all of them, and there are members in our group who differ with the majority position. That's the way politics plays out. I was struck by the first witness who testified in favor of the bill. She testified about a young man who needed medication, a young man who committed suicide. We've all seen the billboards. Stop suicides. Treat depression. Well, there's nothing in this bill that does that. We're going to force people to give up their property, but we refuse to force them to get medical treatment. And I think one thing the testimony has brought out is, the solution is forcing these folks who need mental health care to get it. This bill doesn't do that. Now, let's talk about suicides for just one more minute. In Minnesota, about 80% of firearms homicides are suicides. The Canadian government, after they passed a rigorous restriction bill on firearms in 1975, went out 3 years later and had some researchers do a study. And their conclusion was, Canadians appear to have fully substituted suicide by leaping. I had an 86-year-old widow lady who lives 2 doors down from me who was old, lonely. Her family had grown away from her. She was depressed, and she used clothesline. So there are plenty of substitutes available to people who are determined to take their lives. But to focus on this bill, which I believe doesn't deal with the problem, which is mental health, I think the biggest difficulty is the burden of proof provisions. You have a scale of justice. They're equally weighted. You clip a bit off of your fingernail, and you drop it in one of the trays, and lo and behold, you have a preponderance of the evidence. So we're taking away a constitutional right. We're making a whole bunch of criminal penalties relating to the taking away of the constitutional right on the basis of a nail clipping. Yes, I know I'm overstating it. This is testimony. So I think that is a really serious problem. I think allowing the petition to go to the court without first having gone through the police and having an investigation and a separate judgment made by someone who is not emotionally traumatized as to whether the action should go forward is something that I think that should be seriously considered. I notice on the list of factors, history of mental health evaluations is not in here. Now, sometimes it will be unavailable, but certainly if it is unavailable in these proceedings, the legislature has the power to make it available. And I notice we have for some of these things, you have to be arrested. For some of them, you have to be convicted. For other ones, just anybody's opinion seems to be good enough. That I find as a significant concern. And given the, I know we're running out of time, given the overall impact of the bill, take a look at the top of page 6 if you want to. I'll tell you what it says. If the individual wants to get or have extended a permit, they have to carry the burden of preponderance of the evidence. The victim of the order, that is the person who has had his constitutional right property taken away from him, has to prove, even after 5 years, that he's a good guy, or she is a good person, by clear and convincing evidence. This bill is designed to make it easy to take property away and hard to get it back, even after a great number of years. That, I think, has due process problems. But basically, the bill is...
Professor Olson, you just finish up. You have about 15 seconds.
I'm good at that. CARE 11 had a report last night on a woman who had OFP orders. And the gentleman that was her attacker was ordered to surrender them. He didn't. No affidavit was filed. No enforcement effort was ever taken. They had a long article on the fact that they don't get it done. Not even 2% in Hennepin County. Right now, no one is checking. So an order that doesn't do anything isn't going to advance safety very much. Thank you.
Thank you. Representative O'Neill.
Thank you, Mr. Chair. Representative Pinto, you and I have worked on a lot of legislation together. I respect you. I like working with you. You're an intelligent, articulate man. We've even worked in the area of violence and things like that. And yet I wish this was written differently. You know, you had said that, well, kind of overlook the problems and the details. And if you know me, I cannot do that. I cannot overlook the details. And I have so many notes and so many detail issues that I don't even have time to go into them, Representative Pinto. This bill has significant issues, and I don't say that lightly. I have studied this bill. In fact, last night, you ask anybody, I had 5 statute books open on my desk, cross-referencing, trying to fully understand what you're trying to accomplish here. I understand the issue. I understand the concern. I understand that we're in a situation that we don't want to be in. We're in a society that has kind of gone over the edge. I understand all that, and I would love to work, and I have worked. You and I have worked together to try to get to some of those core issues. You and I worked in the area of violence together. And right now I'm actually looking at civil commitment statutes So I'm working with Representative Keel on reforming our civil commitment statutes. Now you understand that our civil commitment statutes really do get at what you're talking about here. If someone is a danger to themselves or others, they can be taken into custody, they can go and be evaluated, they can go through a 72-hour process. We already have a very robust, and we are still working to make it more robust, system of civil commitment. So if someone truly is a danger to themselves, intimate danger to themselves or others, we have that avenue. As I said about domestic violence, we also have that avenue. You know that the OFP statute that you and I talked about and worked on has a situation that if that woman feels that she is in danger from guns, that those guns can be removed through a court order. And it is a due process, and they can have their court time. So there is that avenue as well. But as I'm getting into the details, Representative Pinto, the very first thing I did is I looked to see, where did you draft this legislation to? And I was just confounded. I don't understand. I mean, it could have been in 609. It could have been in 154. But you put it in 245. You put it in the Department of Human Services chapter, and specifically to follow mental illness crisis housing. And more specifically, immediately thereafter, in adult mental illness crisis housing assistance program. And I know Representative Becker-Finn had said that we want to be so clear that mental illness, and I don't want to misquote you, but we don't want to further stigmatize those with mental illness. And yet it's drafted, and it broke my heart when I looked at that. It's like it's drafted to the mental illness crisis housing part of statute. And I don't know what other message you can send, but that. Let's go to, the testifier had talked briefly about page 6. I don't know that I've ever read this in statute before. It says the respondent, so the person that's had their guns taken away, has the burden to prove that they are not dangerous. Where in our justice system do you have to prove that you are not guilty? I don't even have words. And let's just take this a step further. Representative Pinto, not only do we have the civil commitment statutes, we have the domestic violence statutes. You've put it into the mental illness section of law. You have put a burden on the person that had their guns taken away to prove that they're not dangerous. But the language to say that they could possibly be dangerous. They haven't actually done anything, but there's a potential that maybe they could be. I find that highly problematic. They have done nothing, but they could possibly be. There's an old movie about that, and it's this crazy technology that came out, and I don't know what year it was. And it says, well, we can see into the future, and we know that this person is going to commit a crime, so we're going to incarcerate them. I almost feel like that's where we are. The last thing I'd like for you to address is I want you to explain to those in the room and the committee who the ineligible people already are. This is a part of this particular law change that you're trying to do. And the list is long. I don't know if you even have time to go through the whole list of who already are ineligible to possess or purchase a gun, but the list is very, very long, including anybody with any drug possession, use of any drug, any juvenile that had any violent crime of any kind, anybody that is, according to statute 253B.02, is defined as mentally ill, developmentally disabled, or mentally ill and dangerous. I mean, the list goes on and on and on of who is not eligible to even possess a gun. And I'm not really sure who's left other than people that we might think possibly could maybe hurt somebody. I really don't understand. As I've read this over and over and over, I just don't. You had says, overlook the details. I can't overlook the details. And that's just I could go for an hour talking about this, but that's just the high level things that I have really great concerns about. Not a due process that was mentioned before. So we can do an ex parte hearing, which means the defendant isn't even there to determine whether or not he is dangerous or she is dangerous and take their guns away. There is only one other instance in law that says we can do an ex parte hearing, and it is in the most narrow of circumstances when a woman who is she is being abused terribly, she's terrified of that man, and she can petition the court to have an ex parte hearing. I don't know any other part of law where we allow an ex parte hearing, but you do here. Representative Pinto, I'm sorry, but this is beyond overlooking a few details.
Representative Pinto, would you like to respond?
Yeah, thank you, Mr. Chair, and thank you, Representative O'Neill. And we have had the chance to work on a lot of these issues together. I'll try to address a few of the points that you raised. I think it's really important to recognize that this is modeled on the very orders for protection that you just referenced, right? It's a very, very similar process. This is not, is somebody possibly dangerous? This is there concrete evidence that is presented to a court under oath with penalty of perjury for a court to consider, with the burden being on the petitioner, not on the person in question, but on the petitioner, to say that this person is a significant, well, I'll get to the burden on the respondent in a second, but is the person a significant danger, and is there not an alternative that is adequate, that is possible, that can be used. That is the basic structure of this, and that's the same as the order for protection. As far as where it's put in statute, that is the purpose, and the focus is the dangerousness, members, of the person involved. What you point to about the respondent having their own burden back is that a court, and this again is the same as an order for protection, a court issues an order. That order is sitting out there that says, as a result of all that process, it is true then the respondent may at that point come back before the order expires. Remember, it's a temporary order, and may at that point have the burden. That's the same as any respondent on any court order once the order is issued. So I want to make sure we're really clear that that burden on the respondent comes after a court has issued an order with that full process. Ex parte orders for protection are issued many times a day. I'm kind of looking at Representative Becker-Finn, who also practices in this area. And that piece of it, it's something that is a common thing. The issue here is the danger has to be immediate and present. It is a high standard for doing it. But overall, Representative O'Neill, the point that I would make is this is an important situation. This is a crisis. This is a short session. I want to work with you on any of the details you want to, and any of the members. The next stop for this bill is civil law. Let's keep on working on this. Absolutely. Every part of this, absolutely. This bill was introduced a year ago. I was waiting for a hearing until now. It seemed really important to have it. I would love to continue working with you and with your colleagues. This is an idea that is in use in other states right now. It's fully constitutional. It's happening there. It's an idea that we should consider here, and I'm happy to work with you to finalize it, to make it happen in our state. Thank you, Mr. Chair.
Representative Dean.
Thank you, Mr. Chair. And, you know, when testifier Mr. Dorr spoke, he spoke about life. And I think that that's what this is about. It's about life. And we have not been doing our part as legislators in protecting life of those in our state. We seem to have elevated the issue of guns above protecting life. And we didn't do anything after Sandy Hook. My fear is we're not going to do anything now. And to you, Eva, keep fighting, because I'm not so sure we're going to get there. And if we don't get there, tell all your friends to run against us and get us out of here so we can begin to make this change.
Representative Howell.
Thank you, Mr. Chair. And Representative Pinto, you know, I started marking this thing up, and there's too many marks here to go through them all, but I do have one question. Was this done for you up here on the screen? Is this supposed to be accurate?
It is supposed to be accurate, Representative Howe, but do you see an inaccuracy there?
Well,
please do point it out if you do see something.
Thank you, Mr. Chair. And
sorry,
Pinto,
Mr. Chair,
on the first one, I didn't get up through them all. I just stopped at the first one, because if that one was wrong, I kind of figured the rest of them would probably be in question. So it says that making a false accusation is a felony level crime. But yet here on line 931 says it's a misdemeanor. So I'll stop right there.
And Mr. Chair,
Representative Pinto.
thank you, Mr. Chair. And Representative, what I want to make clear is that perjury is in fact a felony. Thank you, Mr. Chair and Representative. And Mr. Chair, if I could point out that some materials were left up by somebody who was testifying against the bill, including a cell phone. I just want to make sure that that is not forgotten when anybody leaves. Thank you. Okay.
Representative Considine.
Thank you, Mr. Chair. You've talked about the hearing, but as the former law enforcement people can tell you that if they run across somebody, they can take them directly to the hospital and they will put them under a 72-hour hold. And you alluded to it, as did the lady, the libertarian, and that seems to be preferable to lock them up for 72 hours rather than take the guns and do an assessment. Which one is more onerous? In one, you get an assessment, and the other one, you lock them up. I would suggest that just taking the guns is a lot less intrusive than locking them up for 72 hours.
Mr. Chair, to that point?
Representative O'Neill, I also could answer that one myself.
If you would allow me some latitude.
Go ahead, and I'm going to respond on that one as well.
Very well, Mr. Chair, thank you. So I live in a duplex, and my next door neighbor over the summer was quite distraught. Native American, felt very isolated, was going through a divorce. I would see family members come and go. One night I remember 3 of his older adult children standing on the sidewalk. It was really hot, it was September. And I just quickly just said hello. I didn't really know for sure who they were, but what they were doing is they were doing an intervention, and they had just walked out of this intervention with him. He had been sober for 14 years and had recently relapsed and had downward spiraled very, very quickly. 2 days after, that was on a Friday evening. 2 days after that, I left for the weekend. I went away on a Saturday. He went into the garage that we share and set up a ladder and a rope, and he hung himself. Had I known that that's what he was going to do, you're darn right, I would have called the police. I would have put him and made sure that he was committed for 72 hours. And there are so many people just like myself that have encountered that yes, they want to, just taking the guns out of the home doesn't mean that they're not going to commit suicide. There's plenty of other ways to either hurt themselves or other people. And maybe it's more onerous, but at least they're getting treatment, they're getting care. When I used to do jail ministry and I was the preacher in the jail, I used to say, you know what? You need to look at this as a pause button. This is an opportunity for you to pause your life and to think about it and reflect and maybe make a different choice. So I don't see this as more onerous. I think civil commitment is a pause for them to actually, one, save their life or someone else and actually get to the issue. Because I think had he actually been committed, maybe we would have a different outcome right now. Maybe I'd have this very lovely middle-aged man still next door that would bring my trash can in when I need it, and he was an absolute lovely, wonderful man. I miss him terribly. So yes, there are certainly circumstances where we need to do the civil commitment. Just taking the guns away may or may not solve the issue.
Representative Considine as well on those 72-hour holds. Law enforcement does not do the 72-hour hold. They do a transport order. They bring them in the doors. I brought in many, and many times they were going out the doors after evaluation before I was done with my report. Not a lot of them were actually held for that 72 hours, and it's not a full 72 hours unless needed.
Again, Mr. Chair, I worked in locked institutions for 28 years. I understand how it works, but you took them in without even a court hearing, and my point is that, yes, sometimes it is necessary, and it works. Sometimes removing the weapons also would be a logical step that would work.
Representative Googler.
Thank you, Mr. Chair. Well, I think it's pretty obvious that this bill is very controversial, and we've heard great arguments on both sides. My motion will not kill this bill. My motion is, again, to lay it on the table. And obviously, there's much more work to be done. I think this committee, I know that I want to hear more about this from other testifiers. Again, we're looking at a very limited time frame that we've allowed Representative Pinto to come here and make his case. This is tremendous, has tremendous implications for the First Amendment. And so I think it's really on us to do some more work here, and therefore I would make a motion to lay this on the table, Mr. Chair.
Mr.
Motion
Chair,
to lay on the table.
I would request a roll call.
We will have a roll call.
Johnson.
Aye.
Lomer. Hillstrom.
No.
Becker Finn.
No.
Considine.
No.
Dean.
No.
Frankie.
Yes.
Grossel.
Yes.
Howe. Lucero.
Yes.
Newberger.
Yes.
O'Neill. Pinto.
No.
Uglum.
Yes.
Ward. And Zerwas.
Uh, 10 ayes, 6 nays. The bill is laid on the table. I want to thank everybody for Representative Beckerfield.
Yep, thank you, Mr. Chair. And this needs to be stated no matter where the bill is going. So if you'll allow me just a minute. This bill is not just about people harming themselves. There's been very little actual discussion because of the limitations that have been placed on the discussion about domestic violence. And the folks that testified earlier, I think they're the ones that actually made the copy of this article from CARE 11 about the enforcement of orders for protection, which do relate to firearms. And if folks will remember last session, I asked a lot of questions about this, and so I'm working on language on how to fix this, and I hope that those who spoke to this will work with me to fix these loopholes, because this isn't just about people with mental illness and 72-hour holds. This is also about protecting women and other victims of violence to quickly keep themselves safe and to diffuse a situation. So do not forget those folks in this discussion. Thank you.
Good point.